nice room. You won't have it long. He left a call for 7 a.m.
Why don't you go see your boyfriend?
Yeah, he's got a nice room. You won't have it long. He left a call for 7 a.m.
Listen properly.
Can you please look up this site?
See if we can figure out something.
Hiya. Little bit of a glitch there on the start of the intro. It's also very, very bright in here, which is welcome because it's been raining so much. Is that a bit better? Little bit. Lilith was the first one here today. Hey, Lisa, you're nice and early as well. Alice, I'm here on time. That is good because I am not. All right, so quick recap of where we're at. 1, I have a dentist appointment at 3. They always, which is in 2 hours. They always run late, but I'm going to have to figure out a way around keeping it going. Not really sure what the deal is there, or we might have to pause and skip. I don't know. We'll figure that out in the next hour and a half-ish. I just want to do this. I need something to... The light feels like it's burning my eyeballs. Let's see if that'll help. That helps slightly. It's like at that awkward point of day where it's just there. And then we are catching up. Catching up from yesterday's testimony. So at the moment, on the stand is the victim's best friend. And I say it like that because I'm not convinced they were best friends. Like a brother. There may or may not have been an affair on the victim's side that this so-called best friend helped cover up. We're all a bit confused on that. Essentially, this guy likes to do what I just did, trying to get from point A to point B, and that is take the scenic route. So we paused him yesterday because it was the end of the day and we had just, he was riling me up. I needed to go watch something that was really, really very stupid. And I actually ended up watching Judge Daniel Norbeck, I think. How you say his surname? We've watched him before, but he had this girl who went off. I'm downloading and editing things as the week goes, because she F-bombed big time. And I don't want to play that live. I want to cover it. Just a sec. My mom's asking how the dentist was. I just want to let her know that I'm only going at 3. I don't know what the deal is going to be if she wants to pull this tooth out today, because I have dancing tonight. And we literally said that we would not miss this one no matter what. So I don't want to miss it. The summary is in the description also if you're not familiar with the story. Hey, Chini. Hey, Steve. Did I say that already? Can't remember. Let's get going.
Fair to say you didn't know when my...
Let's go back a couple of seconds so that we are all on the same page. So now is going to be the defense attorney questioning him on his grand jury trial words.
Where?
Did you know Michael to be a heavy drinker? Did I read that correctly?
Yeah.
No. We would have beer together, you know, like Thirsty Thursday, we called it. Like
Yeah.
after work.
Yeah.
We'd have like an informal argument session where we talk about work and, you know, solve some of the world's problems over a 6-pack of beer, that kind of stuff. And did you know of Michael to be into hard liquor or anything else? You said, no. In fact, it was the opposite. Because he would always sit down and and I would always sit down and have a good scotch. And these guys would always, you know, have beers. Correct?
100%. Yeah.
Yeah. And you said that because your point was you didn't think Michael was a heavy drinker because all he did was drink beer.
That's not what I said.
That's not what you meant to say?
No, you're putting words in my mouth. Mike was a heavy drinker because he had beers. Mike decided to have beer. Some days he would have a Coke. Some days he have a ginger ale. But if we were out to have a taste or a drink, Mike would have a beer. He only had beers. I had, like I said, usually a taste of scotch.
Okay. Nothing further.
Redirect. Briefly. Mr. McDonald, fair to say you didn't know when Michael...
Sorry, what just happened?
And the kids were...
He said, no. In fact, it was the opposite. Because he would always sit down and and I would always sit down and have a good scotch. And these guys would always, you know, have beers. Correct?
100%. Yeah.
Yeah. And you said that because your point was you didn't think Michael was a heavy drinker because all he did was drink beer.
That's not what I said.
That's not what you meant to say?
No, you're putting words in my mouth. Mike was a heavy drinker because he had beers. Mike decided to have beer. Some days he would have a Coke. Some days he have a ginger ale. But if we were out to have a taste or a drink, Mike would have a beer. He only had beers. I had, like I said, usually a taste of scotch.
Okay. Nothing further.
Redirect. Briefly. Mr. McDonald, fair to say you didn't know when Michael started AA?
Did not know.
Because he never told you he went, right?
He went silent.
You heard from other people and kind of put the pieces together?
Mhm.
And
Yes, it was. Sorry.
when you were just asked about being asked if Michael was a heavy drinker, would you observe Michael when he would drink beer, if he drank beer when you guys were out?
Yes.
Did you have any concerns about his level of intoxication on those times that you were with him?
Oh, Mike held himself well. He wasn't sloppy. He didn't show like he was out of control.
And you were asked on cross-examination about memory issues. Did you, in your time working with Michael Sr., ever observe him to have struggles with gaps in his memory?
No, I didn't. In fact, he was actually doing better as the last couple of years we were together.
And you were asked on cross-examination about the meeting that you had alone with Michael when he called you and asked to meet you at your office. You recall that line of questioning?
Yeah, I remember going there, yes.
And you indicated that you kind of weighed the pros and cons with him.
Tried to, yeah.
And about, what it would mean for him to leave and get separated at that time.
Yes,
And fair to say, you at that point were close with the defendant as well.
the whole family,
And the kids were of a huge concern to you.
100%.
And so you, in weighing the pros and cons with Michael, were talking out with him the bigger picture of what something like this could do to his family, correct?
100%.
And did you later learn that he decided to stay with the defendant?
Yes.
You were also asked about a cell phone. So you said Michael had a work cell phone.
Yeah, I bought all the phones for the guys. Everybody in the company, I paid for the work phones.
And you indicated that a lot of times Michael would get called out to help out with service calls, even when he was only working with you sporadically.
Yeah, 100%, because sometimes the guys were wiped out or they had to be somewhere else the next day. So Mike would pick up the slack if we needed it, yeah.
But did you know him to have another phone that was his own personal phone?
No, I did not.
So was that work number the only number that you had for him?
It was.
Did you know them to have like a landline at their house?
They did.
And were you able to reach him on the landline after he stopped communicating with you?
No, I did not really call the house much after he decided to work things out with Christine. She spoke a lot to my house. She called my family a few times, my wife. And that was about the extent of the conversations. We didn't really communicate much. We figured Mike was separating and doing his thing.
Okay. When you turned off the work phone because he wasn't working for you anymore.
I can't remember if I turned it off though, or if it was just like all done and it was no longer mine. Like the communication was made pretty clear that that wasn't very.
So you were never provided another number to reach him at?
No, that's why I answered the phone that night when I came thinking it was a service call. It was Mike's other cell phone that he called me on, and and I didn't know who it was. I said, hello. I literally answered like I was a service company. Hello, MCC.
And that was the first time that you had talked to Michael on a different number?
That's when I saved the number, yeah.
Nothing further. Thank you.
Recross.
Nothing further. I go.
Witness may step down.
Thank you.
Well,
Current role.
Phone because he wasn't working for you anymore.
I think carry on that service.
Witness may step. Commonwealth may call its next witness.
Thank you. Michael Dillon, please.
I can't believe we saved that 2 seconds.
You may proceed.
Thank you. Good afternoon, sir.
Good afternoon.
In a loud, clear voice, can you please introduce yourself to the jury and spell your last name?
My name is Michael Dillon, Dillon,
And your date of birth, sir.
3/3/1963,
And your address?
56 Keens Way in Pembroke.
Are you employed, sir?
I am.
In what capacity?
I work for the Boston Fire Department.
And what do you do for the Boston Fire
I'm the
Department?
district chief.
What district?
I'm currently assigned to the Arson Investigation Unit, but prior to that, I was in District 9.
When did you switch roles into your current role?
A year ago.
So what was your position back in 2021?
I was a district chief.
And what location was that a district chief of?
District 9, which encompassed Roxbury and part of Jamaica Plain.
And could you just describe some of your general duties and responsibilities when you were district chief of District 9, sir?
I oversaw 3 firehouses in the district, 6 line companies, 3 technical rescue companies. We responded to all incidents in my district. They could be hazmat, building fires, technical rescues, things like that.
And did you know somebody by the name of Michael Ricci?
Yes, I did.
May I approach that? They're not here, but we can get them.
This is what I thought as
How
well.
did you know Michael Ricci?
We were co-workers. I probably met Mike about 15 years ago.
How'd you first meet him?
We worked in the same section of the city. I would see him at incidents.
And where did he work, if you know, when you first met him?
The first time I met him, I believe he was working in Ladder 6, which would be Dorchester.
And can you just describe, actually, let me. Just so there's no mystery to the jury. The exhibits get locked up at lunchtime, and they were locked up and they hadn't come out. And I jinxed Madam Clerk because she just alerted me that time. And I said, you'll be all set. The exhibits are back out from their locked area. Thank you. So I'm just going to show you what was previously marked as Exhibit 1. Do you recognize that photograph, sir?
That's Mike Ricci.
Thank you. And that's the gentleman that you just described you've known for over 15 years, is that correct?
Yes.
And what was your relationship like with Michael Ricci?
We were co-workers. So when I first met him 15 years ago, we worked in the same district basically. And about 12 years ago, I started working in the same firehouse as he. I had a supervisory position and he was a firefighter. We worked together for a few years there.
And what firehouse was that?
That was Engine 14, the Ladder 4 in Dudley Street in Roxbury.
What was your role there and what was his role there?
I was the captain of Engine 14 and he was the firefighter on a Ladder 4.
And aside from your working relationship, did you have a friendship with him?
I would say we were work friends. I didn't socialize with Mike outside of work. I would see him at retirement parties and things like that, but that would be it.
And at some point, sir, did your business relationship change and he was asked to work under you?
In April of 2017, I asked Mike if he would become my aide.
What is an aide?
District chiefs have aides. I consider it a crucial role. I use Mike as a technical advisor for me at incidents. I would rely on his expertise and his experience. He would do day-to-day administrative functions for me. He would take care of the equipment we were assigned. But most importantly, I would rely on him at an incident to let me know if it was progressing properly, if we needed more resources. He accepted, fortunately.
He accepted the position?
Yes.
Is it kind of like a golf caddy in a lot of ways?
I guess you could say that, yeah.
And how long was he, Mr. Michael Ricci, your aide?
Just shy of 4 years.
And as your aide, how often would the two of you work in close proximity?
Daily. He He drove me. We were in the same vehicle daily at incidents. We were very close at work.
And what had you ever had a different aide prior to asking Michael Ricci to be your aide?
Just one prior to him.
And what kind of criteria do you use to select or decide who becomes your aide, sir?
As I said, I believed it to be a crucial position, so I wanted somebody who had experience, who was well liked by other people. He had a steady head. If I asked him to do something, that it would get completed. I wanted somebody who was I could look to, who was very responsible, and I thought that was Mike.
And did he live up to that kind of to that criteria?
I believe he exceeded that.
How so?
Just when he showed up to work, he was ready to go. Anything I ever asked him to do was done quickly. He's just a great guy.
And could you describe what kind of schedule you were working during those 4 years with Michael Ricci?
So we worked a 24-hour shift. Then you would have 2 days off. You would work another 24-hour shift and 4 days off.
And when was the last time you worked with Michael Ricci?
That Friday before his death.
And was that the start of a 4-day off period?
I believe so, yes.
And during the course of those 4 years, specifically drawing your attention to middle of the fall of 2018, what, if any, changes did you see in Michael Ricci?
I didn't notice any changes.
And drawing your attention to the middle of 2019, what, if anything, drew your attention with regard to any injuries he had on him?
He reported to work one morning with 2 black eyes.
Had you ever seen him have black eyes before, sir?
No.
And how was his demeanor that day when he came in with the 2 black eyes?
I would describe it as somber.
Did you ever know Michael to be kind of a barroom brawler?
Never.
And was that the only time you saw Michael Ricci with injuries, sir?
No.
Drawing your attention to a few months prior to his death, did you observe him come to work with another injury?
Yes, a black eye.
And what was his demeanor on that occasion?
I would say the same. He was somber.
And without telling us anything he said to you, sir, both those times you just described, would you have a brief conversation with him about the nature of those injuries?
I did.
And drawing your attention to 1 week before Michael Ricci's death, again, without telling us anything he told you had happened, what, if anything, did you observe on his neck?
He had scratches on his neck.
Had you ever met his wife, Christine Ricci?
Yes.
Ever socialized with her?
No.
Drawing your attention, sir, to the last day you described as working with Michael Ricci, which would have been the Friday before his death. Who, if anyone, came to visit him at the station?
His son, Michael.
Is that Michael Jr.?
Yes.
Had you met him previously?
No,
Had he, as far as you know from others, had he ever come to the station before?
I had never seen him in the station.
And that was the Friday before his death that he came in?
Yes,
Sir, during the time that you knew and worked closely with Michael Ricci, did you ever have any concerns about his drinking habits?
no,
And during that same period of time, did you ever have any concerns, sir, about his memory?
no.
And when was the last time you saw Mr. Ricci?
That Friday before he died.
May I have one moment, please?
You may.
Nothing further.
Cross-exam.
Back to come to sidebar, Your Honor.
You may.
Okay, so if you just jumped in, basically we are rewatching. Well, we're watching for the first time, but we're behind a little bit. I had to go to a friend's screening last night, and so we missed. I think it was like 2 hours ish of yesterday. They are going to be back in court 7:27 at the moment, about an hour and a half. So they basically start court at the exact time my dentist appointment starts. So what we might need to, actually, I think the smartest thing to do is just before I leave, we'll break, and then we'll be slightly behind, skip the sidebars, etc., until we're back on time. But I want to try and finish today's. And there's 7 hour 57. There's about 57-ish minutes. But I still need to get dressed and stuff. I'm just in comfy clothes because it's freaking cold.
I have no questions, Your Honor. Thank you.
The witness may step down. I'll see. Where we are. Jurors were going to spend there. The final conference with the lawyers was to find out where we are. I always like to keep you informed of where we are in the context of how much more evidence. So I expect that the Commonwealth's case, the evidence from the Commonwealth will close on Wednesday. So all day tomorrow and then sometime on Wednesday, the Commonwealth will rest its case. All right. So I give that additional information. Jurors, I send you off tonight with those warnings. Be vigilant to those warnings. Don't talk to anyone about this case. Continue to have open minds and don't do any research about this case. We'll see you back here, ready to work 9 o'clock tomorrow morning. Thank you.
Court, rise for the jury. Just place your notebooks on the chair. Exit mate this way.
Okay, that's them done for the day. So the lawyers argue clearly for about half an hour.
All right. What do either of you wish to discuss before we suspend for the evening?
So maybe now's the good time to talk about the voir dire of Katrina Freeman.
Go right
And,
ahead.
Okay, so I'm sorry I'm pausing so much, but I feel like there's a lot of people that have just jumped in on this day and they might need to know if there's context missing. I don't feel like you need to go and watch that much of the medical examiner. I would watch the son, the daughter. So the daughter is Sophia, the son is Angel. The best friend that was just on at the start of this, I'd go back and watch all of his. And you could probably go through the medical examiners or the crime scene people very quickly where they show the house just to get an idea of like where we are, what's happening. But the rest you don't really need to watch. Katrina Freeman is Angel, the defendant's son's ex-girlfriend, who was living there at the time. So she might have a lot of insight into what was going on in the household. For some reason, defense is worried about her, which makes me kind of keen to see what she has to say. They've been very relaxed with witnesses. This last guy, they were a little bit worried about as well, but it seemed okay. But this Katrina Freeman, they are really like, they keep saying, we need to talk about it, we need to talk about it. Hey, Britta. All the other channels I follow, everyone is in the midst of summer. Oh my gosh, Jenny, I don't know where you are in the country, but Cape Town is, it's not okay. Well, we're not okay. I'm so cold. And it's reached like 8 degrees inside. Yeah, this judge, I absolutely love her. And she's so like graceful. She's beautiful. She's like sophisticated. I'm enjoying her vibes. When she greets the jury for the day, which we'll see later, she looks at each of them for them to say they did manage to keep that. And what we'll do now, if they end early, is we'll watch some Judge Fleischer because we're way behind. Haven't seen him in a bit. Is it unusually cold? So I look back at last year and it said that it was the same temperature. And I remember being cold last year in this house and thinking that this house, either winter was unusually cold or this house was just so much colder than our old house. Our old house was owned by a Polish landlord who had made it so incredibly comfortable to be inside in the cold. South African houses are not built for this weather at all. We don't have radiators. We don't have underfloor heating. We don't have any of that. Most of the time, we just grin and bear it and go for it. Most houses in Cape Town don't have aircon. The temperatures reach about your guys' mid-90s, and we just have fans and work through it. But I think now, this winter, we're going to prepare better. Like after this winter, we're going to prepare better to try and keep the heat in next winter, like putting wall heaters on or something. In Joburg, having beautiful days, but cold nights and early mornings. But Joburg as well is like generally much colder than us in the mornings and the evenings. And then in the day, it's like fine.
So we have a text message that the Commonwealth used to refresh Angel's recollection about the timing of the so-called suicide attempt with a knife.
Somebody get that to me so I can look at it again.
May I approach?
Yes, please.
Your Honor, this is the entire conversation, I believe. Page 14, which is tab, is the relevant portion.
And so it would be helpful to me if one or both of you could walk me through
Okay.
who's talking and what they're saying.
All right. So the bad act that they want to put in is a statement that was disclosed prior to trial, is a statement by Katrina Freeman saying that on May 10th, 2020, she came home from work. She notices the defendant holding a knife to her torso. Well, let me just read. On Mother's Day, May 10th, 2020, Ms. Freeman recalled an incident involving the defendant attempting to harm herself with a knife, and her family was present. Ms. Freeman said that she'd been drinking on this day because she had previously lost her own mother, and as a result, Mother's Day had always been difficult for her. She got home and went downstairs. She recalls coming up the stairs from the basement and seeing the defendant on the floor by the sink with a knife in her hand, and remembers confronting the defendant and saying to her, "Are you really going to do this in front of your children?" She recalls Angel and Michael Sr. trying to help the defendant. That's the bad act in question.
Okay.
The testimony of Angel Ricci was that during the event that he described, Katrina was not present.
Correct.
If we look at the text message on page 14, that is dated May 10th, 2020, the very day she said that she made these observations. And it's clear from the content of those text messages that Angel is describing an event that Katrina was not present at. So in order, obviously, for a prior bad act to be entered, Your Honor has to find to a preponderance standard that the event actually happened. And given the contradiction between both the testimony of Angel and the content of the document that they used to refresh Angel's recollection, which they presumably take to be a fair statement because they used it like that, it looks like she wasn't. And therefore, the bad act that I read of Katrina is one of two things. It's either false or it reflects another bad act that is just somehow either misdated or something like that. If it is the same event and it's not, then there's indication that it's not true. At least her account of it is not true, and therefore should not be allowed to be presented. If, on the other hand, it is a separate event, then it requires the same type of bad act analysis that Your Honor is already engaged in with the other bad acts that they've attempted to get in. But in either case, I think we have to have a clear record about what it is that she's claiming, if it's the same event or a different event. Because if it's a different event, what we're now talking about is potentially 3 self-stabbing events. The June 6, 2019, which corresponds with the date in which Michael Jr. broke his hand when Angel says that he remembers this happening. The May 10th event, which potentially was described on that text message. And then the event that Katrina is talking about where she was present and making this speech to Christine. And again, that needs to be clarified. And then we need to have a separate analysis with regard to the cumulative prejudice of all of this relative to the evidence relating to the charge conduct. And I think the only way to really do that carefully would be to have a voir dire.
Your Honor, just so you are aware of what you are looking at, the blue is Katrina, the green is Angel.
Thank you.
That was your first question. The second is, I think
Green
the
is
reason
Angel. Okay.
the reason why we provided you the whole exchange and the reason why we asked Angel when he was looking at it to look at a few pages before leading up to page 14 was to get the context of the entire conversation. Katrina mentions in that text exchange that she is drunk that day. Angel references how intoxicated she was that day. Excuse me. And there's multiple back and forth about Katrina's concerns about being in the households, about concerns for Sophia, about concerns for Sophia because she has a history of cutting behavior. Before you get to that conversation or that bubble where Angel makes that comment about the big knife, I don't think it's as crystal clear as counsel wants it to be that it's clear she wasn't there from that incident and that Angel's telling her. It's just Angel makes that comment in a series of other conversations about the incident or about what's going on in the household as a whole. Ms. Freeman actually came in and told us about her recollection and her recollection of it being on Mother's Day of 2020 before we even went and located those texts that's an extraction from Angel's phone, not from her phone. It was her memory of what that incident was. And when you heard the testimony from Angel the other day, it wasn't as clear that he was clear as to the timeline. It wasn't as clear about what parts of it he clearly remembered and didn't. I believe when he was asked about whether he recalled Katrina being there on cross-examination, he said he couldn't remember seeing her face there in his memory of it. Therefore, he doesn't believe she was there. That doesn't mean she wasn't there. It just means that his memory of it now is that she might not have been there. I don't think the fact that 2 witnesses have a slightly competing view of the same event doesn't make them not the same incident. And again, the Commonwealth maintains that it is the same incident. We're not alleging there's a third incident. We're alleging that she
What is the harm in voir diring her specific to that issue?
Mhm.
That is the issue of whether or not there's more than one event.
The Commonwealth doesn't have a problem with that.
And or
but-
unwittingly, what I don't want to step into, and I think a valid concern raised by the defense, is the idea that we would unwittingly step into a different prior bad act because of a lack of knowledge. At a minimum, it seems to me to be in everyone's interest for that to be fleshed out before she takes a stand before the jury.
We just asked that the voir dire be limited to that very narrow issue, because counsel did raise a series of issues in relation to Ms. Freeman's testimony. And what we would not want to see happen is his ability to get a chance to examine her fully before she makes a direct testimony. So if the court is inclined to voir dire on that narrow issue, we would certainly have her available before the jury is expected to convene tomorrow.
All right? Counsel?
The only two things that I want to talk to her about, and it doesn't even need to be me that talks to her about it, is to determine, so the court can make a clear finding about whether or not she was there by a preponderance of evidence, given the nature of that text, given the nature of Angel's testimony, and given what she's going to testify to. That's it. I'm not going to do a complete examination outside of the view of the jury. And then the second issue is, well, that's really it. That's the big
And
issue.
is it the same?
Is it the same incident?
Is it the same incident?
Right.
All right. Is it the same incident and was she there? Until I have any other conversation with you, both of you, if I do, that's the limits of what the voir dire will be about. The Commonwealth can start the voir dire, and if defense wishes to ask questions limited to that, I'll hear them.
Thank you, Your Honor.
Thank you. As it relates, I don't know if you want to move on to the Lee Rivera point. I was
Sure.
trying to remember, there was one other small issue, not issue, but in terms of what I would intend to elicit, Your Honor, is literally, I have less than a page of questions just to let the court know, but I would draw her attention to the date that she became involved with the Ricci family, which was June 6, 2019, following Michael Jr.'s going to the hospital because he hurt his hand. This was following, just for your own knowledge, Your Honor, the incident whereby he walked in and his parents were fighting. There were smashed things everywhere. And then ultimately his mother made her way downstairs, got a knife. He thought she was Michael Jr. We anticipate will testify that he then watched his mother head towards exactly where his father went out to smoke a cigarette outside. So we're talking about that incident. Lee Rivera is a DCF caseworker that responded to assist in the investigation of the Ricci family after the hospital filed the 51A. During the course of her investigation, she interviewed the defendant, and the defendant made a couple of different statements that we would seek to elicit. Number one, she denied any physical abuse by Michael Sr. She also was asked about the incident in question that prompted the hospital to file the 51A. And she indicated that she and Michael Sr. were arguing about the affair. He got upset because she continues to bring it up. Junior arrived home while they were arguing, and Junior yelled at her to stop screaming and was trying to grab her. The defendant claims she became upset because of trauma history, which we don't need to get into. Defendant said she was in a, quote, fit of rage and grabbed a mirror in her bedroom, smashing it on the floor, and told him, Junior, maybe I'm just better off dead. She then claimed she grabbed a knife to keep Junior away from her. And that DCF report was provided early on, Your Honor.
All right, can I have a copy of it?
Certainly. May I just have one moment, Your Honor?
Is he still here? Let me hit pause to that button and discuss something else. Juror in seat number 5 recognized someone in the audience. One in the audience.
They cut our sound here.
approach to the side of the bench
Okay.
or to the side of the witness box.
In hindsight, we could have finished this last night. Well, no. That's the thing about doing it live. When you're used to doing it on replay, you can't skip these parts.
And Your Honor, before you engaged in that conversation with that juror, I did pass up to Madam Clerk the DCF records, tabbing 2 different pages that relate to what I stated earlier about Lee Rivera.
All right, just give me a second to make a couple of notes here.
Thank you, Judy.
So, Your Honor, if what they're doing is they're calling Lee Rivera to recharacterize the June 6, 2019 event as being directed towards Michael Jr. and not towards Michael Sr., then I think that constitutes 2 distinct bad acts. And I think there's a real problem with that. I also think it's a real problem that they're going to put sort of they have to decide, is my position, as to how they're going to characterize that event. They have said all along that they thought this event was an event in which Christine was going and charging out in order to do something to Michael. And now they're going to they said it on their opening even. Now they're going to put in a statement of my client suggesting it was directed to someone else before they put on the testimony of that event from Michael Jr. Seems like that's a real problem. And it puts out even more prejudicial issues, and it's directed towards a third party, which Your Honor said was a sort of the red line for you. You know, we talk about prior bad acts, but not prior bad acts to third parties. If that's what they want it for, I think that runs afoul of your own red line. And I think it has this troubling relationship with Michael Jr.'s story, so that now they're going to get their story out through Michael Jr. and they're going to try to characterize it using my client's words, and then try to get Michael Jr. to sort of suggest that she was charging towards Michael Sr. And it's sort of hard for me to know. Well, it just amounts to 2 separate characterizations of a single event.
I think that we could probably excise out or tailor certain statements that my brother indicated are troubling to maybe simplify it. By no means are we trying to offer the defendant's statement to show that she was protecting herself from Michael Jr. In fact, it is my firm belief.
What are you offering it for? Did she change her story?
No, what I'm more saying is that part isn't really that important to me. The part about she grabbed a knife to defend herself against Junior. The more important part is that she was in a fit of rage and broke things. And also when confronted with, has Senior any physical abuse, she denied any physical abuse by him. And in a case involving self-defense, I think that's highly probative. as it relates to, I believe, Your Honor, for whatever it's worth, that statement by the defendant to Lee Rivera about defending herself from Michael Jr., I believe that was a self-serving statement, if anything. She failed to mention anything about going after her husband with a knife or heading in his direction as he walked outside. I think that, I do believe that we could potentially excise out certain portions that if it's, if Your Honor rules that way, of course, we would, conform with whatever your ruling is. But I do believe that the remaining portions of what the Commonwealth suggested it was seeking to elicit is very probative, considering the fact that this was kind of an ongoing pattern that you've allowed us to some extent to bring in through other witnesses. I'm happy to.
All right. I think that the denial of any physical abuse by Michael is permissible, and I will allow that testimony to come in. This characterization or alleged characterization by the defendant as her actions being directed towards Michael Jr. Is not relevant to this jury's decision-making, and I'm not going to allow that to come in.
Okay.
It starts to be wander into perhaps another bad act. I'm not even sure at this point if it is a separate bad act, but it's not relevant to the decision-making with regard to what happened between the defendant and her husband on January 28th, 2021. So it's not coming in, even though it is a statement of the defendant that would be otherwise admissible. I'm exercising my discretion under the evidentiary rules for it to not come in. With regard to reporting that she was in a fit of rage and grabbed the mirror in her bedroom and smashed it on the floor, it seems to me that we expect the testimony from Michael Jr. to be consistent with it. It's cumulative and not harmful in terms of its cumulative effect. I am going to encourage the parties to work towards a stipulation. That's all I'm going to get her to allow her to testify to. So if you can reach a stipulation, we can shorten it. If you can't, that's fine. But she's going to be limited in her testimony to her statement with regard to no denial of physical abuse by Michael in the past, and that she was angry and smashed the mirror
Understood.
on that date.
Okay.
With regard to the rage part of this,
Yes.
I would suggest because it's cumulative, it's less probative and therefore much more likely to be overcome by its prejudicial effect. And in this case, Michael Jr., who was an observer of it, is going to be testifying about it. Her own characterization of her emotional state at that moment sort of short circuits the jury's own ability to listen to Michael Jr.'s testimony about what he saw and make their own determination about it. So I would still object to that portion coming in. I understand with regard to the statements about Michael Sr. as well as the broken glass.
Right. I note your objection. It's her statement.
Thank you.
Any other issues? So we're going to have the voir dire witness ready to go, hopefully at 8:30, if everything else lines up, and we're all ready to go at 8:30, but I'll be ready to go at 8:30 for that. All right?
Okay.
Anything else?
Nothing from the Commonwealth. Thank you.
All right. I appreciate your work on the jury instructions. I haven't had a chance to look at where the differences lie, and I'll start looking at that tonight. I expect that maybe, well, we'll see how the trial plays out, but we'll have an adequate opportunity. The one thing that I wanted defense to focus on is, and I haven't read the case in a while, but the Commonwealth cites to a case in its, with regard to the self-defense instruction. I want the defense to, address that with other legal precedent.
Your Honor, just back to Lee Rivera for one moment, just because I want to make sure it's abundantly clear to myself. There was another portion of her statement with regard to maybe I'm just better off dead. I guess that wasn't brought up as, in terms of your ruling. So I just wanted to, I don't have to go there,
I
but
don't have a problem with
again,
that. I don't have a problem with her statement.
I'm sorry, I just wanted to bring that up. Thank you.
Okay. Anything else?
No, Your Honor.
All right, I'll see y'all in the morning. Have a good night.
Court, all rise.
We're just going to see if there's any interesting hot mics here, or if they're quick to turn off.
I'm gonna steal some candy.
In a courtroom.
Okay, I just want to make sure there was no masses like under one thing. Perfect. All right, thank you. Sorry, that probably was uncomfortable. You're like,
Yeah. Maybe you can find grab.
I'm Jeremy. Nice to meet you.
If you're what?
Sweating. Warm?
It was warm and then hot, and sorry, warm and then cold, and then warm and then cold again. He said, "I'm gonna steal some candy."
They do. I don't know. They must on the weekend, and in the afternoon it always gets warm in here. Once they
Some of
get,
the other ones, like the sun, like.
yeah, next door, that one that gets.
And there goes the mic. Okay, so I am going to put some Judge Fleischer on while I get ready and wrap up, make sure that nobody needs anything from me in the next 45 minutes-ish. No, I mean in the 45 minutes from when I leave. But before I do, what I wanted to say is Ashley Benefield, to me, is more abundantly not guilty than Karen Reed was. I think she is absolutely 100% not guilty. I think he was terrorizing her. I think he played games with her head. I think he made sure that it was mind games, that there wasn't physical things, which I'm not going to say one is worse than the other because it's very personal. I mean, I've seen a lot of comments of women saying, like, I would rather he had just done the one because the other lasted longer. To me, that's not important. To me, the most important thing with this one is that the state is leaning on nobody believed you. I would be interested to know the statistics of DV and DA cases where a woman has not been believed and has landed up dead. Because I'm sure the statistics will make people realize why that is a scary thing for them to say. It also worries me. I was watching, can't actually remember what I was watching, but somebody said in a self-defense case, might have been lawyer, in a self-defense case with a woman involved, you want it to be majority male jurors because male jurors tend to, in general, believe the woman and the need to escalate, whereas female jurors might be more steadfast on it not having to escalate that far, which also made me sad because, like, I don't know. As a woman, I want to, like, believe the woman until proven otherwise, just because like we're supposed to be there for each other. I don't know. I don't know if she is or not, but I know the state for sure dropped the ball. Defense pushes it over the line yesterday when he was told not to ask a question, asked it anyway. I think that it's very difficult because this lawyer has been doing it for how many years? He's 75. He's clearly had a brilliant career. I would love to watch some of his other cases. I think he's doing a great job at advocating. Sure, he takes it too far sometimes, but let's look at the antics of the prosecutor in Hannah Gutierrez Reed, who has now been disbarred. This is not like, it's not new for lawyers to push something in when they're told not to, because it's just going to be stricken and then the jurors have heard it anyway, right? Like, that's lawyering to me. I don't think it's that bad. I'm quite enjoying how he's going right up to that line often. Yes, allegedly she was. I haven't double checked it, and I feel like I heard it half asleep, but let's see. Rust prosecutor. Okay, can we have some trustworthy news sources reporting on this, please? Alec Baldwin plans to sue. I can't find like she's gone against. Okay, so this was today. A special prosecutor is opposing a request by a former movie armorer that she be released from prison while seeking a new trial. I don't see anything from an actual reliable source that says she's disbarred. I would pause on that. I know I just said it, but I saw it, should have fact-checked it, and in fact did not. I had a brain fart moment while I was talking about how lawyers act. So scratch that. Wouldn't be surprised if she is. But she's still on for Hannah Gutierrez, which is shocking to me. Anyway, let's hop over to Fleischer because I need to get ready. I'm starting to get that stressy feeling like I'm going to be late and I'm going to be leaving it to the last minute. Before I am ready, and that never works out for me because then I'm rushing and then they run late, but I can't be like, yo, they always run late and I want to be early so that it's not me if they run late.
I go wrong? Come on up.
Good morning, Mr. Holt. You ready? Morning. Come on up. That was really fun. Is this the only attorney that we have here, I guess now?
I think so.
Because after this, we'll get with Luis then.
Oh,
Yeah.
okay.
All right, good. Are you Mr. Agora?
Yes, Ron.
Good morning, sir. Sir, you're charged with interference with the emergency request for assistance. This is a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Hi, Logan. Good morning.
Good morning. On July 22nd, 2024, officers met with the complainant, who is the defendant's wife. The complainant stated that she and the defendant were arguing in their home, and the defendant pushed her in the throat, causing her to hit that bedroom wall. The complainant stated that she did not feel pain from the assault, but then she tried to call 911. The defendant grabbed her phone and turned her phone off while she was on the phone with Precinct 5 dispatch. The defendant told officers that he and the complainant were arguing to where he had made the mistake of pushing the complainant in the chest area, caused her to be pushed back into the wall. The defendant stated that the defendant called 911 with her phone, and that he grabbed her phone away from her and kept the line because he did not want the police to get involved in their problems. But shortly after, he gave the phone back to her. Officers checked the first 911 call and saw it to last 6 seconds, and that it had been hung up by the defendant. The plan stated that the call petition wanted to document the incident, and that the defendant should not be putting his hands on her. The defendant did not want to pursue charges.
Okay. Mr. Gore, I'm going to find that there's probable cause to go forward with your case. Mr. Holt, so the relationship is she wants to continue to have contact with him, I would imagine.
Yes.
Okay.
Received it off the constitution.
Okay. Understand, sir, that I am ordering you as a condition of your bond not to have any threatening or harassing contact with her. Okay? Not to be in possession of any weapons. I am, for a limited purpose now, going to enter in what's called a magistrate's order of emergency protection that identifies Nadidi Chima as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. This comes also with a residential restriction. However, I will take that off. I don't know what kind of relationship you have with her, but if it's something where you're constantly fighting and you're at each other's heads, be very careful. I don't know if she's a vindictive person. There are a lot of vindictive people in this world. All she has to do is call them up and say, hey, he's threatening me, and boom, who goes to jail?
Yes, sir.
Do you understand what I mean?
Yes, sir.
There's a lot of vindictive people. Watch out. I don't know what kind of person this is. All she has to do is call them and say, hey, man, he's threatening me, and boom, you go to jail. Be careful. All right? All right, you've got a lawyer. Mr. Holt will take care of you. Just stay in touch with him. If he comes back and tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest.
Yes,
Don't pick up any new cases and stay in contact and you'll be fine. All right?
sir. Thank you.
Okay, so we will have you go to Victoria, sign a reset. We'll draft the appropriate paperwork. We'll have you sign it, and after that, you'll be free to go. Okay? All right. Please. Thanks, guys.
Yes.
All right, right this way. He's ready on that stage. For Vasquez.
Yeah, I'm ready.
Can you file no threatening and harassing, please?
Judge, may I approach?
Yes, ma'am. Hi.
The jail load is the system this morning.
Okay.
So 9:30 when my audit starts. But the other jail load, they're gonna be coming in and out as well.
And what did you say your name was?
Francis?
Francis? Okay. I guess no Tracy today then?
No.
Got it. Okay. Well, thanks, Francis. I appreciate it. And how long are you going to be able to stay with us?
Till 9:25 the latest. She'll probably have to sign off.
Oh, that's like 5 minutes.
Yeah. I can say like 5 minutes after.
Well, I don't want to get you in trouble. Where are you going to?
Court 6, just right across the.
Yeah, I don't want you to get in trouble.
We'll go steal her.
Yeah, I guess we'll work it out somehow, one way or the other. Okay. Okay. Yeah, don't worry. We'll work it out.
And for the last client, he signed his conditions, correct?
Say it again.
For the last client, he signed.
It'll be with state bond conditions. You don't have to worry. Yeah.
Good. Which one's clean? Okay, thank you.
So, hey, Vic, no Tracy today, huh?
No,
Should we email or email?
no, they emailed me already and they gave me, so I'm gonna reply to their email when you need help after this. Oh, no, I'm gonna give it to the clerk, so when they sign the bond, she can give them.
Yeah. I'm just waiting. I heard the door back there. I'm waiting for somebody.
Hi. Do you have a plea?
I do, Your Honor.
You ready?
I am.
Come on.
Civic justice.
Oh, got it. All right, they're getting, who's it on?
Reyes. Olden.
It's Vasquez Reyes.
Got it.
Reyes.
Page 47, Judge Vasquez Reyes.
You are.
So we did do it. In regards to information.
Thank you. Hey, on Vasquez Reyes, was there alcohol involved? Can you tell me?
We're actually, thank you. Yeah, I don't have any possession, so
No alcohol. In this assault case?
It's sure, it's a family assault case, the being said, heard around midnight, so. Alcohol has happened.
Say it again. Was there?
I don't see any indication of alcohol, but it's after midnight, that is the,
Okay. Good morning, Mr. Vasquez. Sir, you're charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 60 days in jail, credit for the 28 days. You must understand that you're facing a year. This now comes with an affirmative finding of family violence. What that means is that if you ever pick up another assault like this, you will be facing a third-degree felony, a minimum of 2 years and maximum of 10 years in prison. You can never own a gun or ammunition as a result of this plea bargain as well. You pick up a gun or any kind of weapon, that is a Class A in and of itself. You now are starting to acquire a laundry list of priors, two DWIs, an evading in a motor vehicle, and now this assault case. Is it all due to alcohol? Mr. Vasquez, some people can consume alcohol and deal with it well. Some people cannot consume alcohol and deal with it in a good way. It seems like you might be one of those people. If you cannot control your emotions, if you cannot control yourself when you're consuming alcohol, don't drink. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You also give up the right to appeal. Once you accept this plea, you can never fight this, undo this. This will go on your record. It will be there for the rest of your life. You now have an ICE hold. You will now be shipped off to immigration.
I mean, please, court, I understand that there is.
I'm showing that there was a hold.
Thank you.
I don't know. What do you say? I'm showing that there was that there was a hold. From what I understand, that there is an immigration hold. If you do go to immigration, if you are deported back to your country of origin, get permission before you come back here. If you are busted coming back here, it's a minimum of 5 years in federal prison on an illegal reentry charge. Mr. Vasquez, you will go to immigration now. Get permission before you come back. How do you plead to the offense of assault of a family member? Guilty or not guilty? I will find you guilty, sentence you to 60 days in jail. I'll give you credit for the 28 days that you've done. There's affirmative finding of family violence. Good luck to you, sir. Thank you, counsel.
Right, Judge, the next arraignment is,
Do you want to do any Spanish speakers?
we didn't have any.
No? Okay.
Just
Thanks.
Page 7, Cortez.
Luis Cortez.
I have to grab it, Your Honor.
Okay.
Yeah.
Is he here?
Forgot about this guy.
What happened?
He has a board.
I saw. Is this a new case? Was it a 2B?
The one case, the judge was actually, no, it's the case is 2021, it's been recent a lot of times. I guess he recently didn't show up, so.
Oh, he absconded from,
Yeah.
oof.
From the 338.
I see that. Oh, there was a bond violation, that's one. Oh, no, that's not it. Yeah, I don't know about a PR bond on this one. Good morning, Mr. Cortez. Mr. Cortez, we took you into custody because you have an open warrant for aggravated sexual assault of a child under 14 years old. You've now picked up a DWI with us. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Thank you, Your Honor. On July 22nd, 2024, officers conducted a traffic stop after observing the defendant's vehicle change lanes several times without using turn signal and nearly strike the car and the barrier wall that corrected itself before the impact. Officers observed the defendant to have bloodshot, watery eyes. He appeared disoriented and had slurred speech. The defendant admitted to consuming a vodka cranberry an hour prior. Officers conducted the SMLCs. The CHGN was 606. The walk and turn and the one leg stand could not be completed because the defendant had no leg injury. The DRC was read. The defendant consented to correct. But 5 minutes later refused. Blood work was obtained and blood was drawn.
Okay. Can you check to see if he has any prior to the eyes, please?
Sure.
Mr. Cortez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you have a drug or alcohol problem, I will put you in rehab. Do you understand me? Do you have a valid Texas driver license? Do you have valid liability insurance in your name?
Prior to the driver's license is eligible.
Okay. We will appoint your lawyer today. I am going to take you into custody because you have the open felony warrant. You're also a flight risk. So I don't know about giving you a PR bond with an open, serious case like this, and you had absconded from your case. We don't play games like that, sir. I don't know. If you want me to call her, is she currently representing you there?
Yeah.
So you've hired her for this case here? Okay. It's Emily DeToto Munoz. I'll reach out to her. I have her phone number. So don't send him down, please. All right, sir. Put you back.
Mr. Agora?
All right, Judge, next is page 20. Johnson, Kenneth, come on up.
Are you Kenneth Johnson? I'm not happy with you, Mr. Johnson. You were on bond in this court for a failure to stop and give information. You've now picked up a DWI. You are facing up to 6 months you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Thank you, Your Honor. On July 21st, 2024, officers were dispatched to a water maker in Harris County in reference to a suspicious vehicle in the drive-through line. That vehicle was not moving. The witness stated the defendant was in his vehicle in front of her. The drive-through line is not moving forward. As she drove around the defendant to get in front of him, she saw the defendant pass out in the driver's seat. Shortly thereafter, the defendant struck the rear of the witness's vehicle, causing damage. The defendant then got out of his vehicle, gave the witness a thumbs up, walked inside of the business, who was observed vomiting. As the officer arrived on the scene, officers detected a strong odor of alcohol in his breath, red bloodshot eyes, and slurred speech. The defendant admitted to operating his truck and stated he had drank 2 margaritas. Officer conducted the same body test. HGM was 6, walking turn was 7.8, one leg stand was 4.4. The IC was red. The breath alcohol results were 0.184 and 0.169. He was arrested for DWI with a child under 15 in Fort Bend County in 2016. I believe it was flood natural reckless driving.
How many other DWIs does he have besides that? Mr. Johnson, I'm now taking away your privilege to drive. You have an open FSGI with us, a prior DWI with a child, and now you have another DWI. No more driving. I will have you sign an affidavit with me today promising me you're not going to drive. If I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I'm ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you have a drug or alcohol problem, I will revoke your bond, put you in jail, and put you in a rehab facility. Do you understand? As it stands now, you've picked up a new case, and I'm now revoking your bond on the first case, and I'm taking you into custody. It goes with you. I will reach out to your lawyer, and we'll have him here momentarily. Francis, so we will have to do a portable device on Mr. Johnson. Okay, yeah. That's fine. If you don't have to do it now. We'll just make a list and we'll get it done later at some point.
Judge, the next one is page 21, Kid Trivion.
Vic, can we do a guardian interlock paperwork? So I'm ordering him to have a guardian interlock as well, if he does bond out. But he'll have the portable device because that's, yes, please. So, hey, no, on the FSGI 5001.
Okay. Was it still on the one inside?
Yeah. Johnson.
Just upon conditions of
For
Mr. Abdullah.
okay, that's it.
Should be.
Let's see, where are you?
It's an all cap. It's an all caps. Like he's sticking out.
There it is. No, that's not right. Okay, what is your name, sir? What's the last name? Kidd? Good morning, Mr. Kidd. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Officers were dispatched to an apartment in Harris County. The complainant witness stated that she was assaulted by the defendant who had extended a dating relationship with her on 7/20/2024. Complainant witness stated that the defendant became angry and proceeded to argue with her due to her leaving him. She contacted the police to assist her in leaving the defendant. Complainant witness stated that the defendant screamed profanities at her and informed her that she did not really love him. She stated that the defendant spit in her face during the verbal altercation.
Wait, did you say he's trying to get back together with her?
Yes, sir. Complainant witness stated that she observed the defendant reach inside his pants near his genital area, and then he proceeded to slap her in the front of her face with an unknown liquid in his right hand. She felt pain. After the assault, she stated that the defendant informed her that he slapped her with his own urine. She stated that she would like first.
With an onion ring?
With his urine.
With his urine?
With his urine.
What was it in?
I assume to be his hand. It's urinated and handed out.
Is that not an aggravated assault? I mean, so Mr. Kidd also just had an aggravated robbery disposed 2.5 months ago. What happened with that ag rob?
It was, I believe, 8 years. It was early term, Your Honor.
Same complaining witness or what?
It was in 2015 and, no, it's a different claim. That looks like it was just a random robbery.
Mr. Kidd, I want you to know that I'm going to do everything in my power to protect every single person of Harris County. I don't care who you are. I don't care where you come from. I don't care who you're dealing with, who's next to you. I will do everything in my power. And if I have to put your bond at $230,000 like your ag rob was, I will do it in a heartbeat. Do you understand? You are not allowed to have any contact with this person whatsoever. I'm going to put a GPS monitor on you so I know where you are at all times. I'm ordering you not to have alcohol, any kind of dope, and I'm going to test you on a regular basis so you know now. Do you understand? You are not allowed to have weapons and not to go within 1,000 feet of where she lives or where she works. I will know because of the monitor. And I'm going to tell you now, you have to charge that thing on a daily basis. If that thing goes dead, so do you. Do you understand? You know, I know that spitting at an officer is, assault on a public servant, right? Urinating on your hand and slapping someone. A protective order was issued on the 22nd of this month. I suggest you get to know it, because if you do something to violate the protective order, the state can and will file a violation of a protective order against you. I'm telling you, it's one of the worst cases you can pick up. And the Texas Constitution does not allow me, but in extremely limited circumstances, to hold someone at zero bond. This is one of those cases. So Get to know it. Do you understand? What do you do for a living? How much money do you make a month? We're going to reset your case to give you time to hire a lawyer. I will pay for every single thing that you're doing here that I'm requesting you to do, or not requesting, ordering you to do, will be paid for. So there's absolutely no excuse. If you fail to do any of it, I'm telling you, you got out of jail now because the magistrates gave you a PR bond. I will yank that in a heartbeat. Do you understand? If you can't be good in the free world, I will take the free world away from you. I'm going to have you go to Victoria, sign a reset. After that, you'll eventually get with Francis, and then we'll get you out of here. Don't violate these conditions, Mr. Kidd.
Next is page 22. Kirby, come on up. Kevin. Kirby. Page 26, Palacios, Wendy, come on up.
Yeah.
Go ahead and sign
Good morning, Ms. Palacios. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you.
Thank you, Your Honor. On July 6, 2024, officers were dispatched to address regarding assault and justice charge. The complainant witness stated that while he was driving, the defendant who was sitting in the rear right seat stated, "Stupid motherfucker, you taking me home to get my witness." The defendant from the back seat instructed the complainant into the right side of his face with a closed fist.
So who said that? She said that?
She said that.
Okay.
He was in the back seat, he was driving. He stated that the assault caused him to lose control of the vehicle and hit a pole. The certain the vehicle had front distributed damage and front light quarter damage. Complainant witness stated that he felt pain and was pursue charges. Officers observed the complainant to have dry blood on his right nostril and dry blood on his shirt. The complainant witness identified the defendant as his common-law wife. They stated that they were in a relationship for approximately 10 years, but they were separated for about 5 months.
Okay. What time of day or night was this? And was there alcohol involved?
It was at 4:57 in the morning. And I don't see any indication of alcohol.
Ms. Palacios, I'm going to find that there's probable cause to.
Yes, Your Honor, they were drinking at before and I found that.
It's 4:15 in the morning.
Yeah.
Ms. Palacios, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you consume alcohol or any kind of dope, I will put you in jail. You will not get more PR bonds. Do you understand, man? A protective order was issued on this case on the 20th of this month. I would get to know it because if you violated, the state can and will file a violation of a protective order against you. It's one of the worst cases you can pick up in misdemeanor court. It's the capital murder of misdemeanors. So be very careful. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. Do you understand? As long as you can abide by these conditions, you and I will be fine. Otherwise, there's only one place we're going to put you. All right? What do you do for a living, man? Sorry? How much money do you make a month?
About 8,000.
Okay. We are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, eventually you'll get with Francis for your bond conditions. And after that, you'll be free to go, man. When you come back, please have a lawyer. All right? Okay.
Judge, that's pre-trial prosecution.
Yeah, no alcohol, no dope, no weapons, no contacts, please.
All right, Judge, Kirksey was out in the hallway for shorts. Page 22.
Okay.
Kirksey, come on up.
Good morning, Mr. Kirksey. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, sir.
Thank you, Your Honor. On July 22nd, 2024, officers met with the complainant witness, who is the defendant's fiance. She stated that the defendant came home drunk and began to play loud music, which led to a verbal altercation. The defendant then punched the complaining witness in the right eye with a closed fist, which caused the pain. He then tried to punch her again, but she pushed him away from her and ran away. During this report, complaining witness stated that the defendant pulled a gun on her on January 1st, 2024, and showed images to the officers. The defendant was ID'd by his Texas driver's license, and he stated that he never met complaining witness. He also has an open aggravated assault after the same complaining witness in the 179.
Well, this is out of the same transaction, I would assume, right? Okay.
The ag assault was late report. Late report, she reported them at the same time. But the ag assault occurred on January 1st.
Oh, really?
Yes, sure.
Huh. Have they done anything? Do you know if they're going to revoke the bond upstairs? And then are they going to, so this is a new aggravated assault here. He just pulled a gun. Are you talking about that's a separate incident?
It's a separate incident. She just reported it during the course of the investigation for this report. So they were filed together.
Okay. Mr. Kirksey, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or dope, I will put you in jail. You will not get any more PR bonds. I'm ordering you as a condition of your bond not to have any contact with her. I'm entering in what's called a magistrate's order of emergency protection that identifies her as a protected individual. You cannot commit family violence or an assault against her, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet. Can you file the MOA, please? Go within 200 feet of where she lives or where she works. Do you understand? Yes or no?
Yes, sir. Yes, sir.
In the future, when you come to court, don't wear shorts. Otherwise, we will put you out. Okay? Okay. The only other advice I'm going to give you, Mr. Kirksey, don't go back over there. Okay? Because if you do, it's just things are going to go sideways really fast. Call a friend. Ask them to see if they'll go get the clothes for you. If you go over there, it's really going to go bad. You should be worried about it. I am going to mirror the conditions as in the felony court as well, okay? They ordered you, meaning that they ordered you to have a GPS monitor and not to go near. It says here that the exclusion zone is Ms. Leathers' residence, school, and place of employment, meaning that if you go within a certain feet of those places, the GPS is going to ping. They're going to know about it. We're going to know about it. And then the bonds will just get revoked and raised. So do yourself a favor. Don't go near there, okay? Yeah, you need one. So what do you do for a living? A what? Okay, great. So you have a good income then. Good. Get yourself a good lawyer. You're gonna need it. For now, I'm gonna have you go to Victoria, sign a reset. We're gonna give you 30 days. When you come back, please have a lawyer. After that, I'll get you to meet with Francis for your bond conditions, and after that, you'll be free to go, okay?
Right this way.
Hey, so we're gonna mirror the felony court.
Next judge is Murillo, and it's a printout. It should be there for you.
Should have a printout next to you. Mr. Morello is wrong.
Is that this gentleman?
Yes.
Mr. Murillo?
Yes.
Do you need the cause number, Logan?
Yes, Your Honor. I was trying to find it.
It's, do you want me to give it to you? I have it. It's 252-1229. Are you Diego Murillo? Sir, you're charged with the offense of possession of marijuana. You're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. We cannot afford a lawyer. Our lawyer will be funded to represent you, sir. Okay.
Thank you, Your Honor. On July 23rd, 2024, officers on patrol in Harris County observed a vehicle that was not displaying a front license plate. It also had illegal front tinted windows. They conducted the traffic stop, came in contact with the driver, and immediately smelled a strong odor of marijuana emanating from the inside. A PC search of the vehicle was performed where deputies located a jar of marijuana containing 0.327 ounces of regulated substance.
Okay. Mr. Murillo, do you have a Texas driver license, sir? Then you are not, if you have a license from anywhere, then you are not allowed to drive. I am making that a condition of your bond, and you will sign with me today an affidavit promising me you're not going to drive. I don't care what's going on in your life. I don't care who has to go to school. I don't care what you need, groceries. If you don't have a license and liability insurance, don't drive. Do you understand? Do you have anyone else to watch that child? It's just in general. Yeah, what's going to happen if you go to jail to that child? Consider that when you're out there in the free world. Make smart moves. Otherwise, it will impact other people in your lives in such a way that you may not like. You understand? If you want to drive, go get a license and insurance, come back to me, show me that you have it, and I'll take this restriction off. But until that point, do not drive.
Judge, there's a co-defendant called. Do you have a case number?
Logan, there's a co-defendant in this case? For real?
That's fine with me. Yes, sir. I have the cause of the court, Mr. Cocker.
What is it?
That is 252-1230.
We're gonna have you come up here, swear to us that you're not gonna drive. After that, I'll get you to Victoria. We're gonna have you sign a reset. We're gonna get you out of here to hire a lawyer, and then we'll see you soon. Do not pick up any new cases, and above all else, do not drive. Do you understand? Yes, sir. Okay, come on. Is it on today, Coffer?
7:31.
Okay.
Judge, state's bond condition?
No, I just no driving affidavit, that's it. Okay.
You can go to the living room.
Any more? That's it, okay. Right. Hey,
This way.
hi Trinidad.
Everything that got show on the document.
Okay,
So this one right now, I just got the email Friday. She's still in rehab, rehab, and he had a resistant arrest. I was trying to sort something. He was binge drank that day, so he gets out satisfactory and has information for state there. They may dismiss this case, so he's still in there today. I talked to him this morning in Singapore. I said, shot you the email as well. Shot he's still currently there.
okay.
His discharge date is 8/14. A reset just to the right after that.
You saw it? So there's proof that he's in there? Yeah, okay. I'm cool, whatever date you want, I'm cool. Yes, for sure. Yeah, I just want to make sure he's in there. If he's in there, I'm whatever date you got. Yeah, okay. Thanks. Yep, hi. Good morning.
Good morning. I'm here for Sheila on the shop topic tomorrow.
Okay,
We have a PTI agreement signed and we're hoping to take them off the shop.
okay. What is the agreement?
The agreement is 6 months PTI and heroes restitution.
Is it on, it's not on docket today though. Do you have the cause number?
It's on trial by tomorrow, so we're hoping to get a movement.
How old is the case? Do you know?
Before reset?
Do you have the cause number handy?
Yes.
What is it?
249.
Okay.
0090.
So the case is 8 months old. It's on the motions docket. It's not on a trial docket. I'd like him here though, so I can talk to him about it though. So if you can please have him come and then we'll do the reset, we'll do the intervention, but I want to talk to him, figure out a plan as far as the restitution, because if we set people too far out, they don't do anything. So I'd like to make a game plan with him, but I'm certainly okay with it, you know? Yeah? Okay, sure.
Good morning, Judge.
Hi, good morning.
For the second case, the newest case.
So he's pleading to the new one,
He's pleading to the old.
to the old one, and they're gonna dismiss the new one. Okay. Right. Good morning, Mr. Jones. Okay, so that one's gonna be dismissed, and then, did you say 3-1? All right, so Mr. Jones, you're charged with 2 cases of possession of marijuana. You know, a lot of people like to smoke weed, and that's okay. Texas is not the place, man. Go to California, go to Colorado, you can, as much as you want, you can have it. I mean, I don't know, as much as you want, right? But dude, free and clear, as much as you want. LA, Las Vegas, in Las Vegas, you can do it in Nevada too, right? Go to Nevada, man, and you get the gamble. Texas is not a place though, man. You're gonna keep picking up cases. You're gonna keep going to jail. Know what I mean? Really, not until things change in the Texas legislature is just gonna remain, you know? You're facing up to 6 months in jail and a $2,000 fine. The agreement you have is they're gonna dismiss one, you're pleading to the other one, it's 3 days in jail, credit for one that you've already done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can't undo this or change this. Is this what you want to do? How do you plead to the offense? I will find you guilty. I will follow the agreement. Good luck to you, Mr. Jones. All right. Take care, man. Hey.
He has I assault deadly weapon as a PCF, UCW here. He doesn't want me on his case anymore. He thinks I'm not doing anything, but I mean, while there's just pending, like, clear set up for trial or wait, and his mind is off.
I'll talk to him. It's okay. Just give me a second. Lori.
I have, Rosario Garcia on your jail docket for failed the ID.
Doing the bond hearing, so bond is set at 2,000. I was wondering, would it be inclined to give her a $2 bond?
She's got a continuous that's at no bond right now. Did you see that? How long, did she abscond from the continuous? What happened with that?
Yes, sir. It looks like, your PCLE continuates on, 5/5/2023, and then, the bond violation report was filed on 10/4/2023, and then APS substitution got there. So that looks.
No, I mean, she's been gone for how long? And then she gave a false name. Just when she gets a bond upstairs, if she's able to bond out, come talk to me. We can figure something out.
All right, thank you, Judge.
I'm done with it. Anna. Hi, good morning.
I've gotten a couple in this office this morning.
Okay.
The first one is Mendez.
Mendez?
ARISMENDEZ.
Okay.
This is a legal weakness, but as part of the bond conditions, you ordered him to sign for GE program. And today's just the check-in. He signed up and started the organization on.
You have proof that he signed that?
Yes.
Great. Have you've seen it?
Yes, I have.
Okay. You're an officer for it. I trust you. So as long as you've seen it, I'm gold. So he signed up and he's doing it.
Yes.
Wonderful.
So he couldn't start it until Thursday because of the way it was.
That's okay. I'm glad that he's starting to do. Good. Okay.
So I can just do a regular.
Yeah.
Okay, the next one I have is Williams. Terrell, he's in custody.
Hold on a second. Remember, he's gonna get tested for dope. So admonish him not to use.
Okay.
Because I'm gonna bring him in to test.
Okay.
Okay?
When do you want to attend the test? Right?
I don't know. Let me figure it out. How long? How's it? He got arrested 8:15.
Okay.
He's got to be here. So hold on a second, because that's right 30. So let's do 8:19.
8:19.
Yeah, that gives him a little bit more time just in case. Okay.
The next one is Williams. He's in custody.
Okay.
Terrell.
Tell me about him.
He's got a felony for me on the transaction. I think about trying to approach on it, but the felony is kind of dry.
It's only 117.
Okay.
So it's not that old. Did you want to, is there anything special happening up there or no?
Not that I'm aware of. I don't
Yeah, I mean, it's only,
Okay.
yeah,
Okay, so I'll just.
yeah, for sure. That's it. Yes, ma'am. Good morning. Come on up. Is it Mr. Moton, right? How goes it? So Connor tells me you're a little unhappy. Tell me why.
My felony case, and my attorney told me that it dropped the possession.
Oh,
Not his attorney.
okay, all right. So
He's just not working for me.
what do you want him to do for you? What do you want him to do?
I wanted to file a motion for dismissal. I need a lawyer.
Okay, I mean, he can file a motion for dismissal. I don't know what it's gonna, I mean,
No, I want a new lawyer. I don't want this lawyer.
okay, and then what? Problem is that you've got an aggravated assault, your bond is at 50,000 up there. You also have, it looks like, you picked up the ag assault, right? They let you out of jail, so it looks like you're out in the free world, right? And then while you're out in the free world, you pick up 2 new cases. You pick up, is this right, Pavel? It's Moton, M-O-T-O-N. So they file, it looks like 422 picks up an ag assault with a deadly weapon. And then 51824 picks up an unlawful carrying of a weapon and and a possession of a controlled substance.
They picked me up 30 days after the warrant was filed for the aggravated assault. I was driving.
So let's not talk about the case because I've got DAs here, everything you say they're gonna, so let's not, I just want to know what happened.
That's correct. It was a no arrest ag assault, so we got picked up.
Oh, it had all the stuff on him at the time that he was arrested.
Correct.
Got
So it
it.
was not out on bond yet.
Okay. You're on bond in our court. We gave you a PR bond, right? So that's still in place. Yes, I'm telling you, I'm looking at it. You're on bond in our court. You just haven't made bond in the felon court. That's why you're still in jail. If you had someone that could make the $55,000 bond for you, you could be out in the free world. And then you could be fighting this case from the free world. So you need someone to pony up 55 grand or 10% thereof, and then you can get out. And then you fight the case from out in the free world. The thing is that typically with these cases, the way it happens is we're kind of low on the totem pole because the big deal in your case is the aggravated assault. So we kind of just play the waiting game to see what happens up there. And it's very possible that that case up there swallows up this case here. Depending on what happens there, they may end up dismissing this case as it is. Have you offered that? No?
The preview cases, 13 months.
Yeah, and you got to understand this also is that it takes time to get evidence. It's not immediate. It takes time to get videos, 911 calls, victim statements, witness statements. All this stuff takes time.
I understand.
That's why-
That's what my lawyer Friday told me that they had.
You in the felony case,
Yes,
okay?
my lawyer told me that they talked to the victim. The victim recanted his statement saying that his back was to me. The only reason he knew I had a gun is when he looked at a video.
So don't talk about the case, right?
I'm
What,
just- I'm not lying, I won't lie or anything. I'm a disabled veteran, y'all. And I'm doing time for having my own weapon, protecting myself in my own vehicle.
what would you like from me? If you want me to give you a lawyer, I'm happy to do that. Okay, I will do that for you, but I'm telling you, it's gonna remain the same. What happens now is just gonna remain the same until you're either able to bond out or you take care of the cases upstairs. Pavel, is there an offer upstairs? I'm happy, look, but I'm gonna tell you this now, Mr. Moton. I'm not gonna go through, just because you don't like what they say, I'm not gonna give you a new lawyer every month. Doesn't work. I'm happy to give you a new one now, but I'm not gonna do it again. I'm not gonna do it again. I'm not gonna do it again. You know, it probably the same thing is gonna happen. We're just gonna sit there, I'll give you a new lawyer, and we're gonna reset you until your next case is 9/19, September 19th. Call someone out there, see if you can get your bond posted. That's what you need to do, so you can get out and fight this case from out there. Is there an offer upstairs? There's not even an offer, a plea bargain yet, okay? I'll give you a lawyer today, and then if you have any more issues, just tell the lawyer and I'm happy to talk to you, okay? Okay, for sure. Thanks. Thanks, Con. Hey. Sure.
So I represent Louis Cortez, who is this is his first appearance in the GWI first. I also represent him on the aggravated.
Are you gonna sign on? Okay.
Anyhow, I represent him on the aggravated sexual assault of a child. I have for 4 years. He's been on bond for over 4 years. He's never missed court. Has never.
They said that he did, and that's why they had a warrant issued, because he had missed court.
That's accurate.
Let me see.
So I thought that the bond violation of court was because he got arrested. That's why they thought that he did. But I guess what I'm here, so, you know, I remember I was gonna went up to 3:38, they don't start talking until 10:30.
Okay.
I let the DAs there know that he had been arrested, they already knew, they called the DVR based on the DWI. And I'm not gonna put words in their mouth, but they were less than concerned because he's been such a good.
If, I can't let him go because of the felony warrant, but if you want to go grab one of the bailiffs to come get him, I'm happy to release him to one of the bailiffs. So, and then you can take him upstairs and you can do whatever you need. I do need him to sign conditions here, though, that no drugs, no alcohol, brand new UAs and stuff like that.
Okay, cool. I'll be right back. They start at 10:30.
Yeah, so, yeah. Okay, thanks, Emily. For sure. Hi, for sure. Hi. Okay, Robert, right?
Yes.
Okay.
And I was going to do is that, because we just have, so if you, your coordinator was saying that we have to go to the specific units and make conditions.
Let me see, I don't remember anything.
So, so this time it's also
Hey, on Robert Moore, was he driving the car?
So, yeah, sure, there's a traffic stop about 1:49 in the morning. He also has possession of controlled substance from 2019. That's the
Yeah, but does he have I'm curious if he has a license or not.
Yes. I'll verify that, Your Honor.
So, is he here? Mr. Moore, come up.
His license is on one, Your Honor.
Okay. You now know what happens if you pick up a new case. You pick up a third case, I'm gonna lose it. I'm telling you, your bonds are gonna go wacko. Don't pick up a third case. Don't drive. Don't drive unless you have insurance as well. Do you understand? Okay, be careful out there. It's not hard to be good. All right, good luck. Thanks. Yes, ma'am. Hey.
Morning, Your Honor. I am approaching on Chase on Booker. He is the custody judge. We are going to be waiving a bail hearing. His bond has already been made and is being processed. But I did want to approach the court about some of the bond conditions. He has a DWI that is pending in Delaware, as he said. So his bond conditions include a curfew, a scram device, and no driving. I wanted to see if the court would allow him permission to go to Del Rio to get him to drive straight to Del Rio.
No, I know. He's got two open. And do you mind bringing Mr. Booker out, please?
Yes, sir.
Thanks. Not with two open
I assumed so, Judge, but I wanted to ask. And as far as the curfew goes, 7 to 7, the offense was picked up at 1:46 a.m. So I assume the court would like to keep that curfew in place.
I mean, I can go to 9 o'clock if you want. I'm happy to do that.
Okay.
But I certainly don't want him out in the middle of the night. Does the old jurisdiction, do they know in Del Rio that he's picked this up?
I'm not sure, Your Honor. You can reach out to them.
And how many DWIs does he have?
This is one, Your Honor. I believe it occurred about a month ago. Probably exact date frame. 6/23/2024 is the incident date. So about a month ago.
No. Let me read to you. Let me get him out here first, and then we will talk.
Do you have notes, Your Honor? Yes. Notes.
Okay, no, I mean, I think I misread it.
I hope.
Okay, I thought that he had another DWI in another state as well. It's just this one.
No, just,
I thought he had another DWI elsewhere. Okay.
just one active in Del Rio.
All right, let me.
Otherwise, we would have filed a second.
I believe it's a UCW and the DWI in Del Rio.
Same transaction.
Yeah, same transaction.
How's jail? You know that here in Harris County, we lead the nation per capita in deaths related to alcohol. It's a stupid, sick statistic that we have, we lead. If you watch the news, nearly every other day, someone is dying from a stupid ass DWI. Just, it's a sick statistic. And here, you have an open DWI in Del Rio, and now you have one here. Can you read to me what happened, please?
On July 28th, 2024, at approximately 1:49 in the morning, officers observed a gray pickup truck cross multiple lanes of traffic without using a signal, setting up multiple vehicles in the process. The pickup truck then exited and traveled 55 miles per hour at a 45 mile per hour zone. Officers conducted a traffic stop. Officers made contact with the driver, who was identified as the defendant by his Texas driver's license. They observed no drug, alcohol, or cigarette. He stated that he had 2 to 3 sake shots, and one was to be shot while eating pho in Midtown. Standard field sobriety tests were conducted. 6 of 6 for HGN, were 8 for walk and turn, 2 of 4 for one night stand. The DIC was read, and the breath alcohol content level was 0.144 and 0.136.
I'm going to find that there's probable cause to go forward with your case, Mr. Booker. I am now taking away your privilege to drive permanently. You will be signing with me today an affidavit. This is a promise that you're going to make to me that you're not to drive. I don't care if Jesus needs a ride to church. You drive. I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you get in a car and drive. Do you understand? You are to now have a GPS monitor on you, so I know where you are at all times, and I'm giving you a curfew of 9 p.m. to 6 a.m. I'm telling you, on these types of cases where I have someone on bond for DWI and they pick up another one, I usually make their bonds $30,000 to $50,000 at a minimum. I'm as serious as a heart attack, Mr. Booker. You do one iota to break these bond conditions, I'm going to do that to you. Do you understand? No alcohol, no dope. On your other ankle, you're going to get a scram monitor, so I know that you're not consuming alcohol. You must charge these devices every single day. And if the batteries go dead, so do you. You understand? I will deem you a public danger, make your bond $50,000 to $100,000, and I'll do it in a heartbeat to protect every person in Harris County. What's your permanent living situation? Where do you live? Where's your permanent job?
His mom is here, and his roommates are in Del Rio, and he is looking for a job in Del Rio.
Why?
That's where I want. That's where I want.
We're going to have to work out some kind of solution because I want him testing all the time. And I don't care if you're in Abu Dhabi, you must test on a regular basis. And the first instance that I get that you're a problem, I'm just going to yank your bond in a heartbeat. Do you understand? It is your responsibility to stay in touch with counsel. If she comes back to me and tells me that she can't get a hold of you because you're playing games, I will issue a warrant. I'm going to keep you on a very, very short leash, Mr. Booker. And I'm going to tell you, I will make notes of every single thing that transpired here today with your other open DWI so that if there's one iota of a problem, and I don't care what your excuse is, I will not entertain any excuse. Okay. Thanks. So please don't send them down because we need them signed conditions. And then
They're saying that it's too loud or something's going on with it.
hey, Anna.
Sorry, Judge, this is earlier. I'm here on Garcia.
Garcia's last name?
Yes, Garcia.
Okay. On bond or in jail?
He's on bond.
Okay.
The last time that Mr. Garcia was here, we ordered him to come back today to proof of the job. He has decided to become an entrepreneur and he's opening a flooring business with a friend of his.
Sure. Like home health care?
No, doing flooring and remodeling.
Okay.
I have a proof of a business card they ordered from Office Depot.
That's cute. All right, I'm gonna talk to him here in a second. All right, let me just, Will?
Yes, sir.
Talk to me.
Hey, Judge.
Yeah.
I think Olivia first from Mr. Shua.
Yes.
And you asked me to come by and speak with you on that. So we got he's a 6-month guy.
Yeah, but I want to talk to him too, so that we can make a game plan, because I'm not gonna just, I mean, the case is 8 months old now. I'm just not gonna reset it 6 months in hopes that he gets everything done. Because every time we do that, nothing gets done. So I want to work a game plan of how much restitution is owed, how he's gonna pay it. Does he have a full-time job? What are the conditions do you want?
Just restitution, Judge.
That's it. Okay, so that's my concern is how he's gonna play. Does he even have a job?
Yeah, it's 2,500, so it's on the higher end of it. I was gonna propose because we did either the mother's PCI route or we're gonna apply one that was ours.
Yeah.
But as a meeting stuff with probation services next week, I believe. Just like a payment plan with them, it's used to being supervised.
Okay.
Just like a PTI.
Yeah, but I get it, but I'm gonna set it up with him tomorrow so that we know, because I'm not gonna play this game and that he, on the first time, he pays $1 or pays $10. Oh, I'm sorry, I just don't have it. I'll come back more next month. And then next month he has another $20 or something like that. I'm not gonna play that game. So please, okay?
Yes, sir.
Yeah, thanks.
It's like, it's bubble, kind of like you're talking as water. It's not good at all.
I think it's because the mic is down. Was it always down there?
Which mic?
It's always been done.
Which mic?
It was right there.
I don't know. Let me see if that's better.
Want to start the THAs?
I have. So I have
That's better.
Matthews in the living room. And then the attorney, Mr. Nesmith, is also been trying to zoom in as well. Mr. Matthews is supposed to be here. Mr. Matthews.
Yes.
You were supposed to be here in court. You were not allowed to zoom in. No, you were supposed to be here in court. You were not allowed to zoom in. I'm telling you that now. Okay? I'm taking you out of the room. You're not allowed to, you cannot zoom in. You must be here in person.
Do I need to make my way there?
What? Am I speaking Mandarin?
No, it's breaking up. I didn't understand you, sir.
You must be here in court. You have a reset. You were signed to be here in court and you're ordered to be here in court today.
Okay, I'm about to make my way there then.
Yeah, let's do the chase.
First judge is page 2. Barbie, Tamika, come on up.
Good morning, Ms. Arby. Ma'am, do you have a lawyer today? What are you doing about that? What are you doing about that?
I was just gonna see if I could just read what I need to pay.
You were charged with theft. I will tell you now that a theft conviction is probably one of the worst convictions that you can have, because you will brand yourself a thief forever. No one hires thieves. No one gives loans to thieves. If you want to get an apartment, you will have a very, very difficult time to get an apartment just because you have a theft conviction. I have people that call me to this day asking me, hey man, my crappy ass appointed lawyer pled me to a theft and now I can't get this apartment. Can you take it off? Man, you pled to it. The theft is one of the worst cases you can plead to. By you just saying, oh, I'm gonna take the easy way and I'm just gonna plead, I'll pay it and just go on my way. That is, it's one of, I'm telling you, I'm trying to help you, that it's one of the worst possible things you can do. In life, when you take a half-ass approach to something, what do you get? A half-ass result, right? Right. And this is a criminal case. This will have far-reaching impact. If you plead to this, from now on, you'll be facing a minimum of 30 days in jail. They can also use this to enhance you to a felony punishment. You'll be looking at years instead of days. They're far-reaching impacts that you never even know that exist. So, what do you do in life? Okay, how much money do you make a month? Okay. Did you even try to look for a lawyer? Okay. You need to at least try. There's a gajillion and one lawyers in Harris County. It's a matter of you going to every medium and cold calling and saying, hey, you know, I've got this case. How much do you charge? 99% of the lawyers here will put you on a payment plan where if you pay a couple $100, they'll represent you. You know, you try to get this thing dismissed or try to work the best resolution that you can. But it's a matter of you actually taking the initiative to try to get it done. We're going to give you another 30 days, all right? Okay, please.
Is that more time?
30 days, THA.
Okay, next judge is page 3. Beltran Pablo, come on up.
Eric. Okay. Got it. Good morning, Mr. Beltran. You have a lawyer today.
No, not yet. I'm working on it.
Okay, we'll give you a little bit more time. Get on it, dude. It's already been 43 days. You understand? Okay, head on over there. We'll give you more time.
Okay, next judge is page 5. Jamie, come on up.
Good question.
You know what case it was?
All right, there you go. You're free to go.
How you doing, Doug?
Good morning, Mr. Cheney. You have a lawyer today.
Well, no, I need more time.
Okay, we'll give you more time. You want to head on over there? I'll be signing a receipt.
She'll tell you when to throw the right thing through.
Beltran, go ahead and sign.
All right, go ahead and step in. I'll take it out to this one.
Okay.
Mr. Mixon for a plea, Your Honor. Go ahead and step on it.
Good morning, Mr. Mixon. Sir, charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail. Credit for the 9 days that you've already done. Is this how you understand? You need to understand this charge will go on your record. It's gonna be there for the rest of your life. You can never take it off, Mr. Nixon. You ever been busted for theft before? I don't care here. I mean, anywhere. Okay. You know what happens next? What happens next? Correct. To what? A felony charge. You take a pack of gum, a pack of smokes, a piece of Lego, you'll be looking at years instead of days. You understand? So the next time you get the itch, get out, run away, do something else, because you'll be looking at a boatload of time more than what you're doing now. You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. Is this what you want to do? How do you plead to the offense? Guilty or not guilty? I will find you guilty and I will follow it. If it's enhanced, it'll be abandoned. Good luck to you, sir. Thanks, guys.
All right, Judge, next is page 8. Davis, come on up.
Morning, Mr. Davis.
How you doing, sir?
Mr. Davis, you have a lawyer today. Tell me what you're doing about that.
Working on it, called a few places.
How many places did you call? Okay, and what did they tell you?
The number they were talking about,
Who did you talk to?
I really don't remember the names, but I have to go forward. So I had to call a place over here also. They said they could represent me. Mental lawyer.
What?
Yeah.
Say that again?
They couldn't represent me because they had to be appointed to it, so they couldn't buy it.
Okay. Do you want more time?
Yes, sir.
What do you do for a living?
Borrow, cater.
And how much money do you make a month, Mr. Davis?
In on situation, and on time with that.
How much? I didn't ask you how long it took. I asked you, how much do you make a month?
That's what I'm saying. 3,000, maybe.
Okay, so you need a lawyer to represent you. I mean, you don't qualify for an appointed lawyer. You make too much money. So we will give you more time. When you come back, please have a lawyer. The longer it takes, the worse it off it is for you, you know? Evidence gets destroyed, people forget. All right? Okay.
This way. All right, Judge, page 13.
Hold on, give me 1 second. Hold on. I'm gonna write something down first.
Mr. Davis, go ahead and sign for your reception.
Good morning, Mr. Nesmith.
Good morning, Your Honor. Can you hear me?
I can hear you. What's going on with you?
Yes, Your Honor. We're here for Tyreek Matthews. I believe he may still be in the waiting room for the Zoom. It was for motion for withdrawal.
He's not allowed to be in the way. He's not allowed to Zoom. He has to be here in court.
Sure, Your Honor. Let me, I'm going to tell him right now. He's not far.
I mean, let's do this. He said he's on his way up here.
Yes, Your Honor, he is.
So if you want to do this, if you want to drop me your cell phone. I can reach out to you when he gets here, so you don't have to just sit here and wait.
Yes, Your Honor. It's 346.
No. I mean,
632. Oh,
put it in the chat.
oh, chat. Sure, Your Honor. He's walking in right now, Your Honor. I have a notice from him. He's walking in right now. I'm here in Fort Bend, the smaller court. I'm out now. It's just that my reception's a little bad here.
Just give me a second. We'll wait till he shows up.
Sure.
Hey, Doug, you're free to go. You're welcome.
You want this?
Oh, like a refund?
I'm back. That's right, John. It could be just bad too. Shreya, what's the word?
Dennis Waller on your bond docket. This is just a case where we've been bringing him back a couple of weeks to make sure he's applying for jobs. Great news, he got one. He starts on August 3rd at Aramar.
Where?
Aramar, the food service.
Where is he? Is he here?
Right in the food shirt under the cloth.
You got a job? Great job, man. Good. Wonderful. Great.
So now that he has a job, can we reset it a little bit longer so I can review some body cams and search? Perfect, thank you.
For sure.
Do you want his appearance next?
No, just tell him to behave himself.
I will, and I'll make sure.
Thanks, Shreya. You're the best. You too. You're the best.
Peter, are you able to do that?
Absolutely.
Judge, are you ready for the next DHA?
Come on.
Jump it up.
Just go back, John. Don't put it over.
He sees us walking.
Okay, who's next?
Page 19, Hernandez, come on up. Oscar Hernandez.
Morning, Mr. Hernandez. Oh, we need a translator. Toma asiento. Yo.
The order, please.
Andrew.
The one you took off the city.
Got it.
Yeah. And the one from last week too.
Yeah.
Look, you can't tell me what to do. Hey, don't send Johnson down though. I'm waiting for the lawyer. No, I'm not. No, no, Jake, no, you picked up on your case.
Yeah.
Hey.
I had Ashley Lance on the docket. She's been removed from DWI-PTI. I'm just trying to get her on the docket. And Victoria sent me an email on Thursday, hey, let's put her on Monday today.
She's not here.
I didn't tell her that. I didn't tell her that today. It's my fault. I forgot to tell my client to be here.
Did you tell Miss Grant that she had to be here?
Grant?
She would be here if she knew. I just got off the phone with her.
Well, she was supposed to be here the last time too. She didn't appear.
Which
Right?
one was that?
The violation, right?
This is the first time we've been asked to show up in court for the violation.
Judge, when I get the, emails from Brenda about removals,
Yeah.
I email counsel to have defendant here, and I usually give like a week and a half to get. So
Okay.
it would have been an email sent to you.
Yeah, he sent me an email on Thursday and I said, perfect. And then I guess I got a call or something and I just completely slipped my mind. I didn't tell my client. I didn't tell.
I guess we
she had
SFPF
no notice.
tomorrow.
Can we put her on Wednesday? I have a case in here on Wednesday.
Yeah.
Okay, that's my fault, Judge.
She has to appear Wednesday. She won't come Wednesday.
Yeah, I just got off the phone with her. Thank you, Judge.
Judge Matthews has arrived.
Okay, thanks.
This is a plea for Mr. White, Your Honor.
Okay. Hi, John D.
All right.
Good morning, Mr. White. Mr. White, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 7 days that you've done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, right to be arraigned, charged resident in court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal, so once you accept this agreement, you can never undo this, change this. Do you understand? The only other thing I'm going to advise you is that this is a terrorist threat. Be careful. Don't go back to the same location. Don't continue with the same course of conduct because it could end up with a potentially felony charge. Do you understand? So be good when you get out. That's it. This can be used to enhance your punishment. You can be looking at up to 90 days in jail as a minimum if you pick up any more cases in here. All right? How do you plead to the offense? Guilty or not guilty? I'll find you guilty and we'll follow the agreement, sentence you to it. 3 days in jail. I'll give you credit for the 7 days that you've done. Abandon any enhancements. I'll roll your courthouse here. I won't do anything. And good luck to you, sir. Yes, ma'am.
Good morning. It's Mr. Johnson, Judge. He's taking me in.
Yeah.
I'm just approaching on a bond to see if he can give the bond.
I did. I put up 5,001.
Okay, 5,001. Yes, sir. Thank you. That's all I want to make sure. Thank you, Judge. Fine with that. May I just reset it? Thank you.
He's gonna pop up tomorrow on tomorrow's docket regardless.
Yes, sir.
So, just be aware that he could end up showing up here. If you can get him out before that, okay.
Yes,
But
sir.
I don't know. So
Yes,
just be
sir.
aware
If
that,
not, I'll be back in the morning, or I can just send
You
a
can always
receipt.
zoom in. I have Zoom for you, so you don't have to come all the way over here, okay?
You have Zoom? Oh, thank you.
Next time. Yeah, that way you don't have to run all the way.
Oh, yes, sir. Then I'll just Zoom tomorrow.
Zoom.
Yes, sir. Thank you, Judge. Thank you.
Yes, ma'am.
That is a DWI case. He's already been admitted into the program. His TRAS is scheduled for Wednesday. So August 1st.
Okay.
So he should be done and we should be able to get this thing moved maybe by the end of August.
What do you mean by the end of August?
TRAS is August 1st and then they got to send me a contract which takes 2 or 3 weeks.
Okay, so we'll probably sit you out like 2 weeks, something like that, or 2.5 weeks, make sure that he gets the interlock, there's a DAT and all that jazz. Yeah, okay. Thank you. All right, Mr. Matthews, come up. All right, so counsel, Mr. Nesmith, good morning.
Yes, good morning, Your Honor.
So I have here that you have filed a motion to withdraw.
That's correct, Your Honor.
What's going on?
Yes, Your Honor. Mr. Matthews had retained me for that particular walkthrough, Your Honor, and I'm withdrawing so that Mr. Matthews can have his right to find an attorney of his choosing, whether it be me in the very near future, within days, or any other attorney, Your Honor.
So he's trying to withdraw from your case.
Yes, sir.
Is this what you want?
Yes, sir.
So you now have to go find a new lawyer to represent you.
Yes, sir.
Do you understand this?
Yes, sir.
Okay, we will set you off a couple of weeks. I will grant his motion to withdraw. I will not continue to play this game. So you need to understand, if you continue to have lawyers that want to withdraw from your case, take a look inside. It may not just be the lawyer. You understand?
Yes, sir.
So this is a very serious case that requires attention now, not 2 months, not 3 months down the road. because evidence gets destroyed and it may potentially be evidence that helps you. You understand?
Yes, sir.
We'll set your case off 30 days. You must have a lawyer by then.
Okay.
All right?
Yes, sir.
All right, I will grant your motion to withdraw, Mr. Nesmith, and then we will reset your case to hire a lawyer. I think that we already have all the conditions in this case as needed, right, guys?
Correct, Your Honor. He was given bond conditions and admonished at the last hearing.
Okay. All right, Mr. Matthews, just go ahead, take a seat. We'll get you out of here.
Yes, sir.
Thank you, Your Honor. May I be excused?
I'm sorry?
I'm sorry. May I be dismissed, Your Honor?
Yes, sir. Thank you, Mr. Nesmith.
Thank you.
Yes. Okay. Yeah. Man, so on Brooker back there, we do need bond conditions. Yeah, has a DWI here and he has an open one in Del Rio. So I'm putting on one ankle a scram. On the other one, he gets a GPS monitor with a curfew of 9 p.m. to 6 a.m. No alcohol, no dope, random drug testing, no weapons, no driving. I've also ordered him not to drive. Is that everything? And I think that's it. Yeah, I told her about the I waived the fee.
And how long,
Prior to the GPS, prior to release, the alcohol monitor 1 day after release. Okay, yes, ma'am. Mr. Saldana. Hey, good morning.
All right, I'm home. I'm a bit angry and grumpy, but it's with myself. It's my own doing. I was supposed to do all of this 2 years ago. I delayed and just kind of went, oh, well, I'll get to it when it's a good time. And now I'm in a situation where I don't have a choice. So because it's this tooth, that one, and it's cosmetic, if I want an implant replacement, it will have to be out of pocket, which is about $2,000 US. But I also have to go to a specialist so they can make it. But she said the specialist is like urgent, as in 2 years ago urgent. So I don't know now. I have to contact the specialist and I have to get it sorted. And meanwhile, Lisa's having a terrible time because she spilt cool drink on her laptop, which absolutely sucks. Okay, before I head over, I need to actually portal you because it's going to be the wrong title. And when they remove the current, they should do the implant. So they said that they might not be able, the dentist said they might not be able to do that, but they might be able to do like a temporary solution. But I said to her, like, I'm literally on camera for my job. Like, I ideally would like to have it all sorted at the same time, because she was like ready to pull it now. And I'm like, hold on. First of all, can I drive home? Because if I can't drive home after this, then I can't do it now. Second of all, let me just quickly finish doing this. 3:45, upload thumbnail. Second of all, I can't be without it. Like, I know it's just a shell right now, but I want that shell to cover the gap. Because otherwise there'd be a big dark hole here. Like, literally, you can see it from all angles. And then I have about a bajillion others that also have to be done. So I'm going to have a nice long road of dentist visits. And here's the kicker. Here's the kicker. The dentist I went to last time that I thought I was booking with this time was just a locum. This was a different dentist who is hella intimidating and not as gentle and calm and chill. She's very good, but she's not as like, anyway, let's head over to the other one. They started. We have lots of catching up to do. So I'm going to end. It's going to redirect. It does take a few seconds. Don't panic. I will see you there.